Hello, welcome back to Seniors in Real Estate. I'm Andrea West, your senior real estate specialist, and today I am joined by Shane Barnard, who is an estate planning attorney. Hi, thanks for joining me, Shane.
I'm happy to be here.
Shane, what is an estate planning attorney?
It is a person that guides a client, another person through the important legacy documents, or some people call them end of life, but I don't like to think about them being focused at end of life. I think of them as beautiful, supportive documents that you have during your life that will name persons you want to step in to make decisions for you when you cannot, and for you to pass on your assets, your stuff to your loved ones when you pass away.
That sounds
And
great.
an estate planning attorney helps coach you through all that.
Sounds like everyone should have one of those.
1000%. Anyone who's over the age of 18 who's a legal adult.
Okay. So that's everybody I know, basically.
But no children.
No children.
Yes.
Okay, yeah, obviously you wouldn't need one.
Yep.
So there's is there a too late to start meeting with an estate attorney?
No,
No. Okay.
no, absolutely not. Now is the time to do it, and not when you are in a crisis or you've
Got it.
received a diagnosis and things are stressful or imminent. The time to do it is when things are good.
Yeah.
Things are stable. You are looking to organize a little bit and protect your loved ones and your stuff. Now's the time to do it.
Okay. Good to know. Okay. So when you're talking about leaving people your assets, are you talking about a will? Is that kind of what you're referring to?
Absolutely. And that is the one that most of us have heard about. We're like, okay, we've at least heard about a will. We may not understand exactly what it is or how it works, but a will is one of what I call the two vehicles in which we pass our assets to our loved ones. And the other one is a trust.
So they're not the same thing.
They are not. They are totally different documents, and they
Okay.
perform differently and at different times.
So do I need a will and a trust?
I do. When I work with my clients, I do both.
Okay.
So if I'm doing a trust for my client, they will also have a pour over will. And I don't want to get into the weeds on that, but they will also have that.
Okay.
But if you have a will, that document is going to go through the probate court process.
Now, I know probate from real estate, and whenever somebody sells in probate, I mean, from my understanding, it's not convenient, it's not quick, it's
Nope.
expensive.
Yes.
Why is that? Why, can you tell me a little bit more, like why a will goes through probate and what probate really is?
Yep. So great questions. And probate is the court's process of basically adjudicating who the deceased person is and where their stuff should go. The most perfectly drafted will, doesn't matter who does it, is going to go through probate. So there's no avoidance of probate with a will. Every will is going to go through probate. You mentioned this. It is very expensive. Your probate assets, the assets that will go through the probate court, they will take about 5 to 8% of that fair market
Wow.
value. It takes at least a year in California. So it's not a quick process, which means your beneficiaries you've named in your will not receive anything until the judge gives that final stamp of approval. So it'll take at least a year for your beneficiaries to receive anything.
Wow. So if you're planning on leaving your kids your assets and you're hoping they have a little cushion to live off, they can't get anything for a year.
It's going to take some time.
Okay. So
Correct.
it's not a quick helpful. Now, okay.
And it's public.
Right.
It is public, which means anyone can make a claim, or if they think they have a claim on your estate, anyone can come forward and make a claim on your estate. So it's completely public as well.
Oh, I don't want someone in my business after I'm.
Everyone's going to be in your business.
Ooh,
Yes.
I don't like that. That's
Right.
icky. Yeah.
Even that may be a estranged relative who you've not spoken with for
Oh.
10 years,
Yeah.
and they think that they have a right. They can come to the court and say they have a right. Doesn't mean that they will prevail,
Right.
but they can always come and say
Right.
they think they should.
But your second cousin twice removed is going to
That
show
person,
up and.
that one.
Right. Okay. Got
Correct.
it.
Yep. And so that's the will. And another thing about the will is it's only effective at your death. So during your lifetime, the will doesn't have any power. It doesn't have, you can change it, throw it away. It can be handwritten. It has no power during your lifetime. It's only effective when you pass and it is lodged with the court.
So why even have a will?
Well, you can do some good things.
Okay.
Right? One, you can name the executor of who you want to manage your estate through this process. You can name guardians for your minor children.
Okay.
Maybe you do want court supervision. Maybe
you do.
you want that. I actually literally, no lie, just had a call with a client who said that she knew a woman who was not the happiest woman, and she did not have a good relationship with her children. So she made them go to court, and so she refused to do a trust. She's like, if you want it, you got to work for it.
Okay.
So it was the
All
gift
right,
that
then.
keeps on giving. So
But it was her wishes. so-
it was, but it is a much more timely, expensive, and public process.
Right. I don't like that part.
No, nobody does.
Nobody likes
No,
that.
and the fees for the attorneys as well as the administrative fees for the court, those are statutorily set. So,
Okay.
I mean, an attorney can say, no, I don't want to be paid my statutorily, written fee, but it's very expensive.
Okay. Got it. So that's just money out the window.
It is. It's money out of the inheritance that your loved ones would have
Right.
received.
Right. So if they were going to get $100,000 now, they're losing a lot of that.
They are.
Wow.
They are.
That's a
And,
bummer.
so the court's going to take their share, the administrative costs, the attorneys will take their share.
Yeah.
Of course, creditors must be paid first. And
Right.
then the beneficiaries will get their share.
Got it. So now you said that you can appoint as an executor.
Correct?
So I've also heard that term with trusts.
Ah,
Now, what's the difference with how's a trust
Yes.
different from a will?
great question. A trust, so that's a trustee. So you have the
Okay.
executor of a will, you have the trustee of your trust.
Okay.
So
Okay. So
at-
they're different terms.
They are. And
Great.
at the end of the day, a will is a piece of paper, a trust is a piece of paper. At the end of the day, they are same, they are just vehicles by which we transfer our stuff. But a trust is effective during your lifetime. It's called either a revocable trust, a living trust, a family trust. There's 1,000 names, but it is a trust, and it says, this is how I want to pass my stuff. My trustee, not my executor, is going to do this administration outside of the court's oversight. We don't need the judge to say where stuff should go. This trust document says where we want it to go. I've been appointed as the trustee. Therefore, it is my job to make sure all the beneficiaries named in the trust will receive their gifts, their inheritance.
That sounds much more smooth because then there's no probate, right?
There's no probate.
Okay.
You can avoid probate. You avoid those statutorily set fees, the administrative fees. It is private.
Oh, I like that.
Private is wonderful.
Okay. Yeah.
And you don't have to wait. You're not throwing yourself on the mercy of the court's schedule.
Yeah.
There are some timelines, but a trust administration, which means when you can pass the assets to the beneficiaries, can happen in as short as 120 days.
Oh, wow.
So it's much quicker.
much quicker.
Yes.
Okay. So
Yep.
just a few months then.
Yes. And so I advise all of my clients to go the trust route.
Okay.
It's not more expensive. It's private. It's quicker. And you can plan for your own incapacity within a trust because it's effective during your lifetime as well. And remember, a will is only effective at your death.
Got it. Got it. And so incapacity, because my parents, dementia, cognitive decline, lots of inability to make their own decisions.
Yep.
So something like a power of attorney would come in handy there.
Correct. So, and my mom as well. She
Okay.
passed from Lewy body dementia, as we've talked about.
Yeah.
And so there are 3 vehicles in which you can help plan for your own incapacity. One, the trust, because it's effective during your lifetime. So you can name people, trustees, to step in to be your incapacity trustee, to manage those trust assets for you during your life. So you're still alive, but you do not have capacity to make those decisions.
Right.
So the trust is one document. You mentioned another, the power of attorney, the general durable power of attorney for your finances, naming someone to step in and make financial decisions, handle all of your accounts, pay your mortgage, make sure, the bills are being paid during your lifetime when you are deemed incapacitated.
Right.
And the third, so we have your trust, general durable power of attorney, and we have your healthcare directive.
Right. And that helps with medical stuff,
It
right?
does.
Okay.
You are naming someone to step in to make medical decisions for you on your behalf
Right.
when you're alive, but you cannot.
Right.
And so you want to make sure that you are naming people that you trust, that you've appointed to make those important decisions for you, whether finances or about your person, your body, your medical condition, rather than having to go to court and getting a conservatorship.
Now, a conservatorship, that I've heard before, that's also expensive, right?
Very expensive, and it's the court appointing someone to be a conservator for you.
So it's someone you don't even know.
It may not be,
It
Correct.
may not be.
right?
Okay.
Who knows who that person's going to be?
Right.
Right.
So it's
So-
somebody that you don't know coming in and handling your affairs.
Or maybe, like for Britney
Okay.
Spears, it was her father.
That's true. That's right. Brittany had her dad do it. Yeah.
She didn't.
Okay.
So, but once you get into that, it's hard to get out,
Okay.
right? So you just want to be careful. So you can try and avoid all of that by having these documents, your trust, healthcare directive, and power of attorney ready to go. So you've already named those persons in the event of your incapacity.
Got it. Got it. Hugely helpful.
Huge.
During a crisis and end of
Ab-
life and all of that. yeah.
Absolutely, absolutely. Because there's always that time where things are just getting a little off. Things are not being managed the way they used to. And you're like,
Right.
wow, what is happening here? And you want to make sure you have all that set in place before that crisis, before that diagnosis, before that emergency happens.
Yep. Yeah. Because then it's too late.
Correct.
It's too late.
Which is what happened with my mom. Yep, it was
Yeah.
too late.
Sorry.
That's okay.
Sorry. That's really, really tough.
The irony is shocking.
Indeed. I truly understand going
know?
with my parents. Yes,
Yes.
I do. Oh. So you mentioned that if you don't have a trust in place,
Mhm.
assets go through probate. So what kind of assets go through probate?
Great question. Any real property,
So your house.
your house,
Mm,
that's going to go through probate. And again, remember, it's no matter how perfectly crafted or drafted your will is, that asset goes through probate. Calculate, and it is assessed at the fair market value of that property as of the date of death of the person who owned that home or that real property. Take 5 to 8% of that. And it's really, really expensive. And so if it is a home that you want to gift to a child or gift to somebody, it's going to be vacant, or they won't be able to take or acquire ownership until the court finishes their process.
Wow.
You can avoid that if you take that asset, that home, that real property, and fund it into your revocable living trust.
Got it.
It will avoid that probate process. Another big asset, so we have your home will go through probate, any cash accounts, your bank accounts, your business, mutual funds, CDs, stocks,
Retirement?
No.
Not retirement.
Retirement, I know. This is the only good news. So retirement, whether it's an IRA, a 401k, a 403b, those assets do not go through probate, neither does life insurance.
Oh.
Because when you set up those assets, you assign or you name a beneficiary at the time you set it up. So you've already said where I want these to go. I don't need the court to make that decision, so they will pass outside of probate.
Got it. But anything that doesn't already say who gets it
Correct.
through probate.
Real property, cash accounts, investments,
And do they take 5 to 8% of the cash accounts and investments too?
in total.
Wow.
Mhm.
So your house is $500,000, and then you've got 200,000 in cash, and then another 200,000 in. Oh my goodness,
Yeah.
that adds up.
It adds
They
up.
could take $100,000 there.
It adds up.
Ooh.
I believe the math. Now, don't quote me on this.
Uh-huh.
Don't quote me on this. But if you have a $500,000 estate,
Yeah.
right, you're looking at around, because it's a statutorily set amount, it's around $26,000 that will be
For
taken.
500,000.
Yep.
And that covers the probate and the attorney.
Correct.
Okay. Okay. Okay.
But
That's a
you
lot
can
of money.
avoid all of that by setting up a trust, properly funding your assets into that trust, and just transferring it.
And that's done for a lot less money than 26,000.
A lot.
A lot.
A lot, a lot. Yes. Oh my God. I mean, now granted, it's not free. Right?
No,
You're
of
paying an
course.
attorney to draft it, which I would advise. And you're maybe paying an attorney or someone to help you administer on the back end, but it's going to be less than $26,000.
Seems like a
Fractional.
no-brainer to me.
Fractional.
Yes, fractional. And it's also whoever you trust.
Correct.
You get to pick, and it's not
Correct.
public.
It's not public and it's a lot quicker.
Okay, and it's quicker. That's true.
Yeah,
Seems like all good pros to me.
I think so.
Yeah.
I think so. I would advise everyone to do a trust.
That sounds good. You heard it here first.
You heard it here first, hot off the press.
Get a trust done.
Yes.
So I need to set up a trust. How long does that take, and how long does the trust even last for?
Great questions. Setting up the trust is very quick. It can be, a 3-day turnaround, a 2-week turnaround. It really depends on when I get the information back from my client about who they are, who they want to have step in to make decisions for them, and where they want their stuff to go. Once I have all that information, it's quick. It's week, 2 weeks. So that's easy. How long does it last? Into perpetuity. No, it will last until you pass, right? But it is not a crock pot. You do not want to set it and forget it, because we change, lives change. We have children, we remarry, we get divorced, we sell an asset, we buy an asset. So I recommend, although your trust will last the duration of your lifetime, take a look at it at least every 3 years.
Okay.
And see what has changed, and then, update it. Make tiny little changes to make sure that it reflects who you are at that time.
Is that something that's fairly easy to do?
1,000%, yes.
Okay.
You can call your attorney who has drafted it, which is what I recommend, and say, hey, I want to name a different trustee, or we sold our house, we bought a different house, or we have a new baby in our family. We need our trust to reflect those changes. Great, let's make those changes. It is that simple.
Great.
I think one of the hardest things one of the most challenging things is you have a trust, the person has passed away. It's not been updated for 25 years. So the assets that are listed in the trust are no longer what are actually really in the trust, and they've acquired new assets and it never made it into the trust. So those assets will go through probate.
Oh, no.
Or a child has been born and they've not been accounted for, and the
no.
language of the old trust doesn't, accommodate that. So you never want that to happen.
No.
So keep looking at it.
Okay.
Don't let it get dusty.
Don't let it get dusty.
Keep it fresh.
Good advice.
Yes.
So considering you said a trust is less than $26,000, that's kind of a
Yes.
big range. How much does it actually cost?
Great. There's a range always, and
course.
every practitioner will have their own price point. So some attorneys will charge you a billable hour. So however long it takes them, that's what they'll charge. Others, like myself, do a flat fee. So I meet with my clients, I learn kind of what their situation is, what they want, and then I give a flat fee. I would say a lot of practitioners, the range is going to be anywhere between $1,500 and $6,500, $7,000. But that is for a trust, a will, a healthcare directive, power of attorney for finances, guardian nominations for your minor children, HIPAA authorizations, and deeding your real property into your trust.
Wow.
That range, that is a big range. So what moves that needle up and down? And there are many factors. Is it a single person or a married couple? Do they have children or not? Do they have real property or own real property or not? If they do, is it 1 or is it 4 properties? Do they have a very simple distribution plan, or is it more complex? Do they want assets to be held in trust or given outright? So those are the factors that go into kind of moving that needle, that price up or down.
That makes sense.
So it's hard for some attorneys to say it's going to be this rate, flat rate, no matter what, until you actually learn more about that potential client.
That makes sense. Somebody with 4 properties is going to be more complex than somebody that owns 1.
Or none, correct.
Or none.
Right? Or you have a single person, no children. That might be a more straightforward distribution plan without a trust for the benefit of their children versus a person who does.
That makes
So-
sense.
There are so many different variables, and there is not one right way to do it. There is a legal way, but your plan should be as personal as you and your family.
I like that. Sounds like it's a custom made.
It is, right? It is not a one size fits all. at
That's
all.
great.
Yep.
Great. Well, Shane, thank you so much for joining me
Thank
today.
you.
I think this was really informative, and
I think
hopefully
so.
everyone else did. too.
I think so. And I love talking about this because a lot of us, we're not confronted with these questions until we've had a loved one go through it.
It's true.
And you kind of learn on the job, and then you realize, wow, this is something really important to do. Whether you were thrust into it because there was no plan in place, so you had to go through the probate process, or there was a plan in place, but things had changed, it was outdated. So doing it now without crisis, without an emergency, without a diagnosis is the best time to do it. And it's, to me, it's the best gift you can give to your loved ones.
Well said. Well said.
Thank you.
Yeah,
I do this.
you do. You do. And well, thank you so much for joining
Thank
me
you.
today,
It was
Shane.
my honor. Thank you. It was a pleasure to be here.
Thank you. And thank you for joining us. Hope this was a little bit informative. If you want to reach out to myself or Shane, our contact information is below. I also have a QR code in my banner if you want to book a meeting with me. My name's Andrea West. I'm your senior real estate specialist, and this is Shane Barnard, estate planning attorney. Thanks so
Thank you.
much.
Thank you.